All right, so I am going to be talking tonight about the environmental laws in the coast that pertain uh, and are relevant to Newfoundland and Labrador specifically. This is a presentation that's supported by a grant from the Law Foundation of Newfoundland and Labrador. I want to start off with a land acknowledgement. So I am coming from you today from Unama'ki, which is unceded traditional and unsurrendered territory of the Mi'kmaq peoples. It's also known as Cape Breton and is located in Nova Scotia. And we likely have participants joining us from throughout the province of Newfoundland and Labrador. And so depending on where you're located, you live and work on the unceded and traditional territories of diverse Indigenous groups, including the Beothuk, the Mi'kmaq, the Innu, and the Inuit. And I just want to take a moment to think about some of the things that I'll be talking about tonight, because most of the laws that I'm going to be speaking to are Canadian law, so they're settler colonial laws. And I think it's really important to recognize that these are not the only laws that can pertain to the coastal territories I'll talk about tonight. And they're also not the first laws that have applied to these territories. So there's a number of different Indigenous laws that have applied in some extent or another to territories through the province for a long, long time. And I think it's really important that we recognize that and make space for those laws when we can. So just a little bit about East Coast environmental law. We are a nonprofit legal environmental law charity, and we envision a future where laws and legal systems protect ecological health and promote environmental and climate justice in Atlantic Canada. And we take a pretty dynamic approach to our environmental advocacy, and we work throughout the Atlantic region, so all four of the Atlantic provinces. And we engage with individuals, groups, and communities throughout the region to really ensure that environmental laws and policies, as much as that is in our control, are founded on responsible, transparent, proactive, and inclusive decision-making. And so our work involves things like public legal education, producing reports, being involved in legal reform, and occasionally taking legal actions. So just a quick agenda. I will be speaking for about 15 minutes on the topic of environmental laws in the coast, and I'll be covering various topics, including government jurisdiction and responsibilities in coastal areas. I'll be talking about the laws that deal with coastal activities and development, and specifically around permitting and approvals. I'll talk a little bit about aquaculture, land-based and marine-based pollution, as well as the laws that deal with protecting and conserving coastal areas, which also includes species and habitat protections. And I'll end with a little bit of a discussion on some of the kinds of action that can be taken. So I thought we would start with a kind of a high-level question. What's so special about Newfoundland and Labrador's coast? Why would we go and have a presentation that's so focused specifically on the coast? And I would imagine that a lot of participants tonight probably already have some idea around why our coasts are so important. But I think it's well worth exploring those a little bit. So as a foundation, there are approximately 29,000 kilometers of coastline, which border some really significant bodies of water, including the Gulf of St. Lawrence and the Atlantic Ocean. And there's some really unique and different and dynamic coastal ecosystems found throughout the province. And these coastal ecosystems provide really important ecosystem functions and services that are beneficial for humans and animals and plants, and generally the environment and our biodiversity. Some of the services and functions that ecosystems provide include protection against the risks and challenges associated with sea level rise, coastal flooding and coastal erosion, and storm surge, which are really being increased in the climate change crisis. And then there's some other practical services and functions that are a little bit more immediate. For example, water filtration and purification, And then if you take an ecosystem like salt marshes, they provide really important carbon sequestering functions. So for example, salt marshes and the plants in those ecosystems will actually draw carbon into their root systems and into the plants and into the subsoil and sequester that carbon. So it's a really important function. And then of course, coasts also provide a ton of unique ecosystems and habitats for species, as well as being a spot where you can find some of those species. So as an example, the Barron's willow is a threatened or endangered species under the protection of law. And it is endemic to Newfoundland, and specifically the northern peninsula of Newfoundland, or the northwest coast of Newfoundland. And it is only found in Newfoundland, and specifically the limestone barrens ecosystems found on that kind of tip of Newfoundland. So this is a really important species. And because it's found only in the coastal area of Newfoundland, it's one of those, reasons to really focus on the coast and think about how important our coasts are. So I want to get us started with a little bit of foundation in jurisdiction. I'm really thinking about where responsibilities lie in terms of our federal and provincial governments. And the starting point is our Constitution, and specifically the Constitution Act of 1867, which sets out the various kinds of matters over which the federal or provincial governments have some responsibility. And specifically, sections 91 and section 92 set out some very specific responsibilities, but there are some other relevant sections. If matters aren't listed in those sections, generally the approach is that federal and government will share responsibilities. Now, there are some very explicit and exclusive matters of federal jurisdiction, and those include kind of the typical things that I think most people are familiar with, like fisheries and shipping and navigation, as well as some of the activities that are associated with those areas. So for example, you can imagine wharves or canals or public harbors that have a direct link to fisheries or shipping, and those are also federally regulated. Federal government also has lawmaking power over federal crown lands, and generally are responsible for the land and water from the low water mark all the way seaward out to 200 nautical miles, which is the limit of the exclusive economic zone and federal jurisdiction. And that's kind of set by international law. But the provincial responsibilities under the Constitution do include local works, undertakings, and matters. They include property rights, jurisdiction over natural resources, as well as provincial crown lands. And then the province has jurisdiction from the low water mark inward. So generally from that low water mark where federal jurisdiction ends into the coast, except for where there's spots where there's either private property or federal crown lands. And just an additional note on this, as a general rule of thumb, the space between the high water mark and the low water mark, so that strip all along the coast, is generally provincial jurisdiction and provincial crown land. And that's a really important point that I'll speak to again. There are some other rights and responsibilities from other levels of government. I've already mentioned Indigenous laws may very well apply to a vast array of coastal territories in Newfoundland and Labrador. There can also be municipal bylaws that are applicable, and occasionally there are private property rights and responsibilities that may also be applicable. I won't have time to cover all of those different laws and bylaws and private property rights, but you can find some more information in our summary series about those. I'm going to stick mostly to federal and provincial jurisdiction. So I'm going to start with our first topic and dive right into coastal development and some of the laws and policies that deal with coastal developments and generally activities that occur on the coast. So there's no general coastal law or policy at either the federal or provincial law that deals with all of the coast or deals with the coast as one big topic or in a holistic way. So often what we're left with is a number of different federal and provincial laws and regulations and policies that deal with specific aspects of the coast or deal with general matters that have applicability to the coast in some situations. And in terms of this topic, I'll really be talking about permitting and approval regimes that help govern the coast. I do want to point out that Section 35 of the Constitution Act of 1982 does create a constitutional duty for governments to consult with Indigenous peoples, duty to engage nation to nation with Indigenous peoples before engaging in any kind of activity that would threaten constitutionally protected Aboriginal rights or treaty rights, as well as a corresponding duty to accommodate. And so, for example, if there's going to be government action that allows for development or activity to take place, that can trigger that duty to consult and to accommodate. So beginning with the federal laws, and there's a number of federal laws that can apply to the coast and coastal development, in addition to these four that I've selected as kind of the key laws. Unfortunately, just bearing in mind that we only have a certain amount of time, I'm just going to focus on these. So the first one is the Fisheries Act. And the Fisheries Act will require an approval for any activity or any development that can cause the death of fish or can cause harmful alteration, disruption, or destruction of fish habitat. And that harmful alteration, disruption, and destruction is sometimes called or referred to as a HAD or HAAD. So if you are interested in learning a little bit more about potential permits or approvals that would be applicable to a specific project or a specific activity, there is a Public Fisheries Act registry that does have records of all of the fish and fish habitat protections, approvals, and permitting. The next federal law that's relevant is the Canadian Navigable Waters Act. And this deals with navigation and marine transportation. And so anytime there's a development or an activity that would impair that navigation, an approval is required. And there's really kind of two types of projects under the Act: major works and minor works. And each of these types of works is further defined in the major works order or the minor works order that are created under the Act. And so for minor works, there's no approval required, but public notice will be required for some kinds of projects. And some examples that are specific to coastal areas are erosion protection works or dredging activities. There's also a requirement to seek an approval for major projects, and these are projects that may have substantial interference on navigation or transportation. And some of the projects would include causeways and aquaculture. And just like the Fisheries Act, there is a public registry where you can find out more information and seek out some of those specific terms and conditions that are associated with authorizations that are issued under the Act. Turning to the Species at Risk Act, this law deals with impacts on threatened and endangered species that are listed under the Act. And you can find out more about those species in the registry and in the Act. And this Act does require a permit or an agreement anytime one of the listed species might be, or their habitats might be impacted. And very similar is the Migratory Birds Convention Act, which also has a list of species, in that case migratory birds, which are found in the schedule under the Act. And so anytime a project or development or activity would impact migratory birds, a permit will be required. There's also lots of provincial laws that can deal with coastal development. Again, there's more than the four that I've listed here, but these are kind of the key ones to keep in mind. So the Labrador Inuit Land Claims Agreement is an agreement between the Nunatsiavut government and the governments of Newfoundland, Labrador, and the Canadian government that was finalized in 2005 and establishes a modern treaty under the Constitution. And it sets out a number of Inuit rights that are specifically laid out in the agreement. And that includes several governance rights that can help inform and shape Inuit stewardship of coastal lands. So the Land Claims Agreement establishes the Labrador Inuit settlement area, where those rights are recognized, And it also creates another area, the Labrador Inuit lands, in which certain pretty extensive jurisdictional rights to govern those lands are set out. And so in the case of Labrador Inuit lands and projects in those lands, there would be pretty extensive jurisdiction for Inuit governance structures and laws to apply, in addition to provincial and federal laws. The Environmental Protection Act is a pretty important law, and I'll talk a little bit more later under some of the other subjects. And one of the big kind of key pieces of the Environmental Protection Act regime is environmental assessment. So there are certain projects that are listed in the environmental assessment regulations, certain types of projects or activities that automatically require or trigger an environmental assessment. And some of those projects have very specific coastal components. You can imagine an aquaculture operation would be one of those projects where peat is collected or excavated, and specifically this would be peat coming from salt marshes, as long as that project will take up an area of more than 2 hectares. Certain construction projects like breakwaters, dikes, levees, or other flood controlling structures, canals or artificial waterways, drainage of land if it's more than 50 hectares, and this can include coastal land, land infilling or reclamation of an underwater area, either if it is in an estuary or a portion of an estuary, or if the total area is more than 5 hectares. And any project that will modify more than a kilometer of water course, which can include the coastline and the coastal waters, will require an environmental assessment. Another very important act is the Lands Act. And this act deals with management of crown lands. And so, as I mentioned, that area between the high watermark and low watermark around the province is generally considered provincial crown lands. So it has a pretty significant bearing on the management of coastal developments and activities. So a lease, a permit, or other approval will generally always be required for any kind of project or activity that goes on in these coastal crown lands. And there isn't a requirement that if a project is within 15 meters of a seashore, a foreshore, or any kind of lake, pond, or river, which can include lagoons and tidal ponds and freshwater lakes that are in a coastal area, the notice of intent is required. So this is public notice of the project. And these notifications are actually available online on the website for the Department of Fisheries, Forestry, and Agriculture. I should note that very recently, the Minister of Fisheries and Forestry and Agriculture suggested that the act is being reviewed. So that's just something to keep in mind for the future. The Water Resources Act is obviously another really important act when we think about coastal development and activities. It's ministered by the Department of Environment and Climate Change and is really designed for any kind of control, management, regulation of water resources in the province. And any activity will require a permit for what are called undertakings. And undertakings include any projects that, among other things, store, use, or divert water, or divert the flow of water. So projects like drinking water and wastewater projects, any kind of developments in protected public water supply areas, including various ones in coastal areas, alterations to a body of water, and well drilling or construction. There is a publicly accessible registry called the Water Resources Regulatory Permits Mapping Application, available on the website for the department, and you can find out more about the specific permits that actually have been supplied for projects and activities. When the minister makes a decision about whether or not a permit should be approved under the Water Resources Act, the minister has to consider a number of factors that are set out in the Act. And one of these factors includes whether the proposal will contravene a provincial policy, will be in contravention of a provincial policy. So policies are really important in helping to understand and shape and guide that permitting process. And there's two policies that are created under the Water Resources Act that I'd like to take a little bit of a look at. So the first is the policy for development in shore water zones. And this is used to establish criteria for permits that are going to be located in shore water zones, which is that interface between the land and water, that kind of foreshore area. And it really includes all of the coastal area. And so certain types of activities are not allowed if they would aggravate flooding, they would cause unmitigable adverse water quality impacts, or they would lead to sediment being accumulated. The other policy that's really important is the policy for development in wetlands. And this is, I think, really applicable to salt marshes and other kinds of coastal wetlands. And it really establishes criteria for any kind of development activities that might affect those wetlands. And the objective of the policy is to permit developments, and keep that in mind, it's to permit developments that do not adversely affect water quality, characteristics, and habitats in wetlands. And so certain developments are not permitted. And again, these are ones that would aggravate flooding problems or have adverse water quality or hydrologic impacts. That are located in recharge zones for groundwater wells, as well as dumping of sewage and industrial wastes that have potential to impair water quality. And I point out that objective that it is to permit development, because this is kind of a theme throughout the policies, that really it's a very narrow approach to environmental protection and a really broad approach to permitting development. So, for example, at the introduction for the policy for development in wetlands, the quote as follows: "The problem facing wetland management is that the ecological and socioeconomic benefits of these ecosystems are not usually directly measurable, and in many instances are not recognized until it is too late," which is very true. However, the extensive nature of wetlands, peatlands in particular, in this province means that there is room for more developments to occur to meet social and economic needs. And so really there does tend to be a focus in the policies, both for the development of wetlands, but also for development in shore water zones, to have those developments proceed. And there's a lot of discretion built in for the minister to decide to allow development through the permitting system. So on that note, I think we'll move on to pollution on the coast, our second kind of topic area. And pollution can be either land-based or marine-based. And a general rule of thumb is that the source of pollution, whether it's marine-based or land-based, will often be a pretty good indicator of which level of government might actually be responsible. So generally, if pollution is coming from a marine area, it would be federal law that would apply. And if pollution is coming from provincial land, including private property, it'll be provincial legislation that will apply. Kind of the big exception to the land-based piece is that any pollution that's coming from federal crown lands will trigger federal law. And so we will start with the Fisheries Act. The Fisheries Act is a really important and significant environmental law because of very specifically this section, or this subsection 36.3, which prohibits everyone from depositing a deleterious substance into any kind of water that's frequented by fish under any conditions where that deleterious substance will enter water. And a deleterious substance can be pretty much anything if it would degrade or alter the water in a way that would render it to be deleterious to fish. Basically, a deleterious substance can be anything from water itself. So for example, you can imagine hot water being put into a body of water that might be deleterious, to very toxic substances that are obviously, or I would say obviously deleterious. There are, however, some regulations that are created under the Fisheries Act that do grant some exemptions for activities that otherwise would release or may release deleterious substances. So examples of these regulations are the pulp and paper effluent regulations, wastewater systems effluent regulations, which deal with municipal wastewater systems and exempt those activities, and then aquaculture activities regulations, which deal obviously with aquaculture, and we'll talk a little bit more about that later. There are many different kinds of regulations under the Fisheries Act, and so there are other kinds of activities that are exempted. Any of these activities that are exempted still have to meet the conditions that are set out in those regulations. So, for example, there may be certain thresholds or limitations on what can be released, and anything over those would still mean that that provision applies and that substance becomes a deleterious substance, which is prohibited. Another federal law that is very important for marine pollution, but also land-based pollution, is the Canadian Environmental Protection Act. And this deals with toxic substances and contaminants. There is a toxic substance list in Schedule 1 under the Act. And if a substance is one of those listed and is released into the coast, then this act will apply. There's also a prohibition on any person or ship from depositing a substance in Canada's internal waters, territorial sea, or the exclusive economic zone, unless it's done in accordance with a Canadian permit. I will also note that there is a legal duty to report a deposit or a potential deposit of a toxic substance into the environment, including the water, a duty to prevent that deposit as much as possible, and a duty to notify the public of that deposit. And we have finally the Canada Shipping Act, which is really important because it implements a number of international shipping rules and requirements for pollution prevention, primarily under the vessel pollution and dangerous chemicals regulation. And this deals with a whole host of potential sources of marine-based pollution, and that mainly come from vessels and ships, but also some offshore platforms. For instance, offshore oil and gas platforms. And so some of the areas that it deals with includes ballast water, garbage, gray water, sewage, and there's various kinds of requirements for these things. So for example, the release of garbage from ships is entirely banned if the release is in internal waters. Gray water is not allowed to be released if there's going to be a sheen or a solid. And sewage is not allowed to be discharged in untreated way within 3 nautical miles of the shoreline. So some pretty intensive requirements for vessels. Now moving over to land-based pollution, there's all kinds of different sources of land-based pollution, including pesticides, sewage and wastewater, garbage, nutrients and sediments, often associated with agricultural activities or mining activities. And so there's a whole host of federal and provincial laws that potentially could be applicable. And I've already mentioned the Canadian Environmental Protection Act. At the provincial level, the main law is the Environmental Protection Act. And this deals generally with the release of any substance into the environment if it is released in an amount, concentration, or at a rate of release that would cause or may cause an adverse effect. And so those releases are prohibited under the Act unless they're authorized by the minister. There's also a corresponding or similar provision or prohibition against the release of waste onto water or onto land, which can include water. And there are various regulations that are created under the Environmental Protection Act that also deal with sources of land-based pollution like waste. So as an example, the pesticides control regulations prohibit the control, use, or commercial application of pesticides without varying kinds of licenses. And it prohibits any kind of commercial operation from allowing pesticides to drain into watercourses. So moving on to aquaculture, which is obviously a very coastal type of project. Aquaculture generally involves human rearing of fish or shellfish or marine plant species. And often in the case of finfish, aquaculture involves open net pens or cages being placed in coastal waters. So there is a shared or collaborative method to governing aquaculture in Canada and in Newfoundland. And so there are both federal and provincial laws that apply, and I'll talk a little bit more about how that all works. The main laws that apply to aquaculture are the Fisheries Act at the federal level and the Aquaculture Act at the provincial level. Also good to keep in mind is that the relationship and the collaboration between the province and the federal government is managed under a memorandum of understanding. And this MOU was actually signed between the federal government and all 4 of the Atlantic provinces in early 2021. And it deals primarily with ways that the provinces can collaborate and develop aquaculture. So under the Federal Fisheries Act, there's several different provisions and sections and regulations that apply. Sections 44 and 45 of the Fisheries Act deal with licensing for aquaculture dealing with marine plants, if that harvesting of marine plants is outside of the provincial jurisdiction. So any kind of marine plants that are being harvested below or outside of the low water mark, beyond that mark. There are also aquaculture activities regulations that apply to operations that cultivate fish. And these are the regulations that exempt aquaculture operations where there may be a deleterious substance released into waters frequented by fish. And so those prohibitions don't apply to aquaculture operations if they have received an aquaculture license, either federal or provincial aquaculture license, and they meet the requirements, the other requirements for monitoring and limiting pesticides that are set out in the aquaculture activities regulations. There's also a potential federal aquaculture act coming from the Department of Fisheries and Oceans, but there's really no indication for when that act might be created. It's been out there for a little while now, and we really have no idea if it would actually apply to Newfoundland and Labrador. And at the provincial level, similar to all of the other Atlantic provinces, the province has an aquaculture act. In this case, it is administered by the Department of Fisheries, Forestry, and Agriculture. And this really sets out the aquaculture regime, including licensing, various standards that apply to operations around medication and feed and disease prevention, as well as land designation and leasing protocols. Generally, no one may enter into or carry out any kind of aquaculture, unless they have an aquaculture license that's issued by the minister. And as I noted before, in terms of the Lands Act, if aquaculture operations will be carried out on provincial crown land, then they will very likely require a lease or a permit or both. There's also some prohibitions in the Aquaculture Act that prevent anyone from introducing, transporting, or transferring live aquatic plants or animals from one spot of the province to another without a permit. And the Act envisions the creation of a registrar who would keep records about aquaculture licenses and leases around Crown lands, as well as associated environmental assessment reports, including preview reports and impact statements. And the registrar would make those available to the public, except for the confidential information that's defined in the aquaculture regulations created under the Act. And it's really important to note that there is an aquaculture policy and procedurals manual, and this is a pretty extensive document. One of its objectives is to promote the development of an environmentally sustainable aquaculture industry in the province. And it sets out all kinds of different requirements and processes as part of that permitting process or licensing process for aquaculture under the Aquaculture Act. And so there are some requirements. For example, applications must include an environmental and waste management plan, and there are requirements for public consultation for any new aquaculture license applications, as well as any applications to the department for a boundary amendment for an existing aquaculture operation. The public consultation requirements include requiring the proponent to provide notice, so public notice in multiple newspapers for a certain amount of time, as well as requiring that the public consultation be at least 20 business days. There are also some other requirements set out in the manual. For example, applicants must have considered environmental impacts and have adequate plans to address monitoring and waste management. So as I mentioned, there is some collaboration between the provinces and the federal government, And that is because there is no clarity at this point in Canada around who actually has jurisdiction over aquaculture. And there is a pretty strong claim that the federal government actually has exclusive jurisdiction over aquaculture, and that the provinces actually don't have the right to make laws for aquaculture. And this really stems from a case in 2009 coming from the British Columbia Supreme Court in a case called Morton v. British Columbia. And in that case, a biologist, Dr. Morton, challenged provincial legislation, laws and regulations that were aimed at licensing of aquaculture. And they contain provisions very similar to the provisions that are set out in the Provincial Aquaculture Act in Newfoundland and Labrador. And so Dr. Morton challenged those laws on the basis that in the Constitution, and specifically Section 91 of the Constitution Act of 1867, actually sets out that the federal government has exclusive jurisdiction over the fisheries. And so the argument was that aquaculture is part of fisheries. Those provincial laws were regulating fisheries, and therefore the province was acting outside of its constitutional jurisdiction. And the court did agree. It struck down almost all of those laws and regulations. The only ones it left in place and intact were regulations that dealt with marine plants, because the court decided not to consider whether marine plants also included or were part of fisheries or something else. And now aquaculture is actually regulated federally in British Columbia. Now, this is a decision of the British Columbia Supreme Court. It's not a case that's binding on other courts in other provinces. And so there is still some uncertainty about whether this would affect aquaculture in the Atlantic region, including in Newfoundland and Labrador, but something to keep in mind. So moving on to our last kind of coastal topic, legally protected coastal areas. And this is a really neat one because there's lots of different types of laws and tools that can be used at the federal and provincial level to identify and manage protected areas, to conserve habitats, to protect species or species habitats in the coastal areas around Newfoundland and Labrador. And so there's various tools provincially and federally. Federally, there are kind of two main tools. There's kind of generally marine protected areas, which are really any kind of areas that are legally given protection by law. And you can create various kinds of marine protected areas under the Oceans Act, the Canada Wildlife Act, the National Marine Conservation Areas Act, as well as other mechanisms, for example, under the Fisheries Act and creating fisheries closures. In addition to marine protected areas, there are also national parks. And I'm going to focus a little bit on the marine protected areas under the Oceans Act and the national parks, but I will touch on the others. So the Ocean Act defines a marine protected area as any part of the internal waters, territorial sea, or exclusive economic zone that's designated to conserve or protect species, their habitats, or biodiversity. So pretty broad mandate on what a marine protected area can be. Now, marine protected areas under the Oceans Act can take months, years, even decades to create and finalize. And it's really kind of a four-step process or that's involved in marine protected areas, both through the development and management. So the first step is planning. And this involves pretty extensive stakeholder engagement and engagement with scientists and the public and governments to try to identify certain ecosystems or habitats or species that really need protection by a marine protected area. So it really involves identifying the areas, the AOIs or the areas of interest that will eventually become a marine protected area. After an area is kind of identified and has been kind of shaped, the next step is policy development, which is the process of determining the various conservation and protection objectives, thinking about possibly zoning a marine protected area into different zones with different levels of protection, as well as establishing various advisory mechanisms or committees that will help manage that MPA and feed into the monitoring of that MPA. The third step is creating regulations, and there is a process, a formal process to creating regulations under the Oceans Act. And then the final step is really marine protected area management and monitoring, and that's an ongoing process that's led by the federal government, but is shaped and guided by various advisory groups and advisory committees for each marine protected area. And those advisory groups generally involve both government and non-government representatives, including of community groups, of industry groups, of nonprofit environmental groups that input into that process and provide advice. So there are a couple of marine protected areas in Newfoundland, both on the coast and then on the offshore, in offshore regions. One of those is the Gilbert Bay Marine Protected Areas, and it's created by the Gilbert Bay MPA regulations. And so just like all of, or many of the other regulations that create marine protected areas, these regulations prohibit any activity that either disturbs, damages, destroys, or somehow removes living matter, organisms, or habitat from the marine protected area. Now, this marine protected area was created in 2005, and it's approximately 60 square kilometers in size. And it's a good example of the way that some marine protected areas use a zoning approach to providing protection. So in this case, there's 4 different zones, and in each of those zones, there's various kinds of activities that are either restricted or prohibited or promoted. And this is an approach that is frequently used in marine protected areas. Another example of a marine protected area in Newfoundland is the Eastport Marine Protected Area. And you'll actually see on the map that there's 2 red areas. There's kind of in the middle near Duck Island, and then further down Round Island. And this is actually 2 separate areas that form the Eastport Marine Protected Area. And they're actually inside of a lobster management area. And the main conservation objective in this marine protected area is to conserve and protect lobster. And in these marine protected areas, there's actually no take zones. You're not allowed to fish. And after this marine protected area was established, there was actually noticeable improvements in the population of lobsters around those MPAs, including in those lobster management areas. There are other mechanisms federally available that can protect coastal areas. One example is the Canada Wildlife Act and National Wildlife Areas. And these wildlife areas can include either terrestrial territory with marine components, and they can also include offshore areas that are entirely marine based. And these are really intended to preserve habitat for either migratory birds or other species with a focus on endangered species. Unfortunately, Newfoundland and Labrador is one of the 2 provinces and territories, the other one being Prince Edward Island, that does not have a national wildlife area. And the National Marine Conservation Areas Act is another really important law that allows Parks Canada to protect and conserve representative examples of our natural and cultural heritage and marine heritage, as well as to provide opportunities for public and education and enjoyment of those areas. But like national wildlife areas, there are no national marine conservation areas currently planned or existing in Newfoundland and Labrador. I also mentioned national parks. And the Canada National Parks Act does allow for the establishment of either national parks or national park reserves. And these are focused on preserving and conserving critical habitat. Within national parks, as many of you may be familiar, no person is generally allowed to use or occupy those lands except with a permit or other approval issued by the minister. However, I will note that Indigenous peoples do have the right to carry on harvesting of traditional renewable resources in national park reserves. And I say that they have the right under Canadian law. There are 4 national parks in Newfoundland and Labrador, and 3 of them are coastal or have coastal components. So the Terra Nova National Park was the province's first national park, and it has a core protected area that makes up about 93% of the total park, which includes intertidal areas along the coast and islands that are protected. The Gross Moor National Park has approximately 6% of the total park that's set aside to preserve unique, threatened, and endangered features. And these areas do include many coastal features, including Shallow Bay, which includes dune systems and beaches, Bellow Downs Island, which is an important habitat for seabirds, and St. Paul's Inlet Marsh, as well as coastal ponds that support various kinds of coastal species. For instance, the mountain fern, which is an endangered species. And this final national park is cooperatively managed with Inuit, and about 8% of the park is in the Labrador Inuit settlement area, and is actually then subject to the Labrador Inuit Land Claims Agreement and the various Inuit laws that might apply. There are also some ways to protect coastal land through provincial law, and these are kind of the 4 key ways. So again, under the Lands Act, and specifically thinking about provincial crown land, there's actually incredibly broad authority in the Lands Act for the minister to set aside provincial crown lands. And with approval from the lieutenant governor and council, those lands can be quite large. And really the setting aside of those lands is for any purpose and for any period that's set out in an order that sets those aside. So this is a really broad authority for the minister to set aside and protect land for pretty much any purpose. And it could be used to protect really valuable and important coastal areas. The lieutenant governor and council can also designate an area of provincial crown lands as a special management area, and then create regulations that can prohibit or restrict various activities within that area. And again, there's really no criteria that shapes how these decisions are made, so it can be really broadly applied to protect coastal areas. There's currently 4 special management areas created under the Lands Act in Newfoundland and Labrador. One of them, the Torngat Mountains, was actually created to establish a national park, and there is now a national park in that area. And then as an example, the Main River Special Management Area does have coastal components, and it was set aside to maintain ecological integrity. Within that management area, some activities are permitted, but one of the activities that's not is mining. The Provincial Parks Act is another important act that the province can use to set aside and protect and conserve coastal land and other land. And these parks are designated through regulation by the minister. And there's various kinds of prohibitions against certain activities like mining and excavation that are found in the provincial park regulations. There's 32 provincial parks altogether in the province. 10 of them are provincial park reserves where there's certain activities not allowed. And then there are some that are coastal components. The Provincial Wildlife Act is another act that can be used to set aside habitat. And the minister under the act can create either wildlife park or wildlife reserve. And this really protects the habitat of various kinds of species. For example, the habitat of the endangered piping plover, which lives almost exclusively on beaches. It can create prohibitions in regulation for activities going on in those areas, unless there's a permit. The Wilderness and Ecological Reserves Act is one other law that the province can use to set aside coastal land or protect coastal land. And it is used to set aside various areas of the province for the benefit, education, and enjoyment of the province's people. And there's 2 types of areas. Wilderness reserves are areas where there's basically no activity allowed. And ecological reserves are areas that contain representative or unique ecosystems or species or natural phenomena, but some activities are allowed. Now, there is no definition in the Act or its regulations on what the terms representative or unique mean. And so there potentially is a lot of scope or broad discretion for the minister to set aside really important coastal areas under this Act. And then there's specific regulations that are created under the Act that actually can create further prohibitions on various kinds of activities in their respective reserves. And so nearing the end, and thinking about all of these laws and rules, both at the provincial and federal level, but also at the municipal and indigenous levels, as well as kind of thinking about the private property rights, I think people are probably interested, or I would assume are interested in taking action of some sort. And so taking action almost always begins with gathering information. Information will help you determine what kind of laws apply and which levels of government are actually responsible so that you can start to tailor your approach. So some questions that are really important to ask yourself, especially when you're in a coastal area where you have all of these different laws and jurisdictions all coming together and colliding, think about, is the activity or the project that I'm concerned about or that I want to undertake going to be in an area above or below the low water mark? If it takes place below the low water mark, it's almost 100% going to be federal jurisdiction that applies or federal laws that apply. Are there certain kinds of species or habitats in the area that might be protected? For example, under the Species at Risk Act or the Migratory Birds Convention Act federally or equivalent provincial acts? Does the project impact fish or fish habitat? Because if it does, the Fisheries Act will apply. The Fisheries Act will almost always apply in a coastal situation. Thinking about sources of marine and land pollution, well, where is that pollution coming from? Is it coming from an activity that's occurring offshore, or is it coming from an activity that's occurring on land, or coming from federal, provincial, crown land, or private land? That will help determine what laws apply and potentially what levels of government are responsible. And then think about all of those different public registries that are available either online or sometimes in government offices. And think about what kinds of permits or approvals are on the registry. Does a project actually have an approval or permit, or is it operating illegally? If there are permits or approvals, what are the conditions associated with those permits or approvals? And is that activity meeting those requirements? And these pieces of information will help you determine some of the rights and responsibilities that may apply in that coastal area to that coastal activity or that coastal project. And that can help set the foundation of other kinds of action. Often a second stage is to report illegal activity. And this is why it's really important to know which provincial or federal department or agency is responsible. It's also worthwhile to think about whether a relevant law or regulation that governs a situation may have specific reporting mechanisms available to you. So for example, in Newfoundland and Labrador, the Environmental Protection Act has a formal investigation process where if you believe some illegal activity is taking place in contravention of the Environmental Protection Act, you can actually take steps to begin an investigation. And so if you think about the Environmental Protection Act and the general prohibitions against releasing substances into the environment that can have adverse impacts, it can have really broad application. Now, those investigative processes will require a formal affidavit. So it actually requires you to submit a legal document swearing the truth of what you believe as an illegal activity to begin that process. There's all kinds of ways to participate in environmental and government decision-making processes. So you can participate in just general public advocacy. So you can advocate to your your elected representative, either at the federal, provincial, or municipal level, or you can engage in politics directly. You can participate in various kinds of decision-making processes, either by writing submissions or potentially appearing before boards. For example, if you think about the provincial environmental assessment process, there are various ways to become involved, from writing comments on draft documents and reports to appearing before an expert panel. And you can also think about other kinds of advocacy tools like petitions. And finally, you can take legal action, and there's all kinds of different ways to take legal action. You can take action privately, either against the government or another private property owner. And there's various causes of action that apply in environmental law. Some of the examples are nuisance or negligence or trespass, but there are many others. And it's always best to think about seeking legal representation or some assistance from a lawyer when you're thinking about those kinds of private actions and taking people to court. There's also statutory appeal, and so some federal and provincial laws actually have a specific appeal process that's set out in that law that allows you to appeal or have a decision by a decision maker reviewed. And where the statutory appeal process is not possible or is not set out in a law, there's also the avenue of a judicial review, which is when you ask a court to think about whether a decision has been lawfully made and fairly made. And just an extra way of taking action, you can also take non-legal action in other ways. So you can think about tools like mediation, restorative justice, and negotiation when you're thinking about taking action to try to address coastal issues and challenges. So that will do it for the presentation webinar, but I just want to highlight again that our environmental laws for the coast, Newfoundland and Labrador summary series. And I also want to just say thank you to the Law Foundation of Newfoundland and Labrador for the funding that made this presentation and the summary series possible.